and welcome to this week's video blog on the law. In past video blogs, we've talked about reasons why people challenge wills. Undue influence and unfairness are two common reasons. A third reason is that the will does not meet the formal drafting requirements for a valid will. There are three such requirements for a valid will. First, the will must be in writing. Second, the will must be signed at the end. And third, it must be properly witnessed. Prior to fairly recent changes in BC law, if the will was missing one of these three key elements, for example, if it was not witnessed, the courts would invalidate the will. However, in 2014, the legal framework surrounding wills and estates in British Columbia changed with the introduction of new legislation called the Wills, Estates, Succession Act. One of the biggest developments contained in the new law was something called a curative provision. This means that in cases where wills do not fully satisfy the formal requirements, the courts can now cure or fix the deficiencies and pronounce a will valid. However, to be able to invoke these powers, the court must be satisfied of two things. First, the court must be satisfied that the document is authentic. Essentially, this means the court asks, was this document prepared by the deceased? Second, and most importantly, the court must ask, does this document truly represent the intentions of the deceased? That is it a fixed and final expression of the deceased's wishes? Or in other words, did the person making the document mean for it to be their final will? The courts, in determining whether a document represents a valid will look to a wide variety of evidence. This evidence includes the presence of the deceased's handwriting, whether the will had witness signatures, whether the document revoked previous wills, whether the testator included plans for funeral arrangements, and whether the testator included specific gifts. Over the last 2 years, people have tried creatively to prove a number of different documents as valid wills. These range from handwritten notes on scrap paper to journal entries to letters. Although the courts are given broad powers, the further a document departs from the formal requirements, the harder it may be for the court to find it embodies the deceased's intentions. In the end, it is always best to seek the advice of a lawyer in finalizing your will. Failing to do so can mean your final wishes may be ignored. I hope that you have learned something about the law from this video blog. Please feel free to like us on Facebook, follow us on Twitter, or subscribe to our YouTube channel to receive notice of our future weekly video blogs on the law. Thank you.